Good afternoon. I am honored to introduce our moderator, Judge Ryan Nelson. President Trump nominated Judge Nelson in May of last year, and he was confirmed in October by the U.S. Senate. Judge Nelson is the youngest circuit judge confirmed to the Ninth Circuit from Idaho and has chambers in his hometown of Idaho Falls. Judge Nelson has been a member of the Federalist Society for a long time. I think I have him beat, though, by a few years, actually, but in any event. Prior to his confirmation, Judge Nelson served as general counsel of Idaho Falls-based Metallica Incorporated for 9 years. Before joining Metallica, he served in all three branches of federal government, including as special counsel for Supreme Court nominations for the Senate Judiciary Committee, Deputy General Counsel to the White House Office of Management and Budget, and Deputy Assistant Attorney General in the Environment and Natural Resources Division of the U.S. DOJ. Prior to joining the DOJ, Judge Nelson practiced in the Washington, D.C. office of Sidley Austin. Judge Nelson had served as a law clerk to Judges Charles Brower and Richard Mosk of the Iran-U.S. Claims Tribunal at The Hague, and as a law clerk to the Senate Legal Counsel, now D.C. Circuit Judge Tom Griffin. He earned his BA from Brigham Young University, and he also earned his JD there with honors. He was also an editor of the Law Review there. So please join me in welcoming Judge Nelson as our moderator.
It's good to be here and with all of you. Today we've got a great panel of experts to discuss the recent Supreme Court case in Janus, and there's a lot of interesting issues. I'll start by introducing the panel. We're joined by Bill Messenger, who's a staff attorney with the National Right to Work Legal Defense and Education Foundation. He's litigated over 100 cases in this area at the appellate level on behalf of the foundation, on behalf of foundation-aided employees and other individuals. He has argued 3 U.S. Supreme Court cases, including a couple of particular relevance to this, the Harris, which was a predecessor to Janus, and then he also argued the Janus case as well, winning that case in a 5-4 decision. We've also joined by Stephen Greenhut. Stephen Greenhut is Senior Fellow and Western Region Director at the R Street Institute. He's responsible for overseeing R Street's efforts in California, Oregon, Washington State, Nevada, Arizona, Alaska, and Hawaii. He authors a lot of op-eds and policy studies. He's also the author of a book that he published in 2009 called Plunder: How Public Employee Unions Are Raiding Treasuries, Controlling Our Lives, and Bankrupting the Nation. He is a 2005 recipient of the Thomas Paine Award, and he received his bachelor's degree from George Washington University in 1982. And finally, we have the Honorable Chuck Reed. He's a member of Hopkins and Carley's real estate practice in the San Jose office. He was mayor of San Jose from 2007 to 2014, a member of the city council from 2000 to 2006, and the city and county planning commissioner for 14 years before being elected to office. Before taking office as mayor of the 10th largest city in the country, he was a lawyer in private practice in San Jose. He's been recognized as a national leader by the New York Times, the Wall Street Journal, the Washington Post, other national media, the U.S. Conference of Mayors, and the National League of Cities. With that, I'm going to turn the time over. Each of the panelists will take 10 to 15 minutes to discuss aspects of the case and the implications of it, and then we'll field some questions. So go ahead, Bill.
Thank you, Your Honor. And what I'd like to do is just give a very brief history of Janus and what the court ultimately held, because I think what we'd like to focus on today as a panel is what's going to happen in the future. But you can't really talk about the future until there's at least a basic understanding of the past. And so what was issued in Janus is what's called a union shop or agency shop agreement. And what that requires is that all employees have to pay dues to a union as a condition of their employment. If they don't, they're fired. And these agency shop, union shop provisions originated in the private sector around the time of the New Deal and were authorized by federal private sector labor statutes like the Railway Labor Act, National Labor Relations Act. And then in the 1960s, according to a case called Street, the Supreme Court held that these union shop provisions in the private sector, you could only compel employees to pay for union costs of collective bargaining, but you couldn't force individuals to pay union dues used for politics. And so the court created that division as a matter of statutory interpretation and to avoid constitutional problems. But then also in the 1960s, you had a new phenomenon, which was unionization of public sector employees. It's sort of hard to picture now, especially in a state like California, but in the 1950s and earlier, the idea of unionizing public sector employees was somewhat unheard of. They simply weren't unionized. But starting in the late 50s and then in the 60s, the idea started to take root of unionizing public sector employees. And that included bringing with it the idea of the union shop, of requiring that public sector employees to keep a job with the government had to pay dues to a union. Now, this brought up profound First Amendment problems, because, of course, the public sector union's function is to bargain with the government, or to put it in the parlance of the First Amendment, to petition the government for a redress of grievances. So as applied to the public sector, what you had in a union shop agreement was the government was forcing individuals to support an interest group to attempt to influence the government. And so there were very quickly cases brought saying that's unconstitutional under the First Amendment. That's compelled speech, that's compelled association. And the first case that reached the Supreme Court on that was a case called Abood versus Detroit Board of Education. And what the court did in Abood, the majority opinion, was to bring the private sector dichotomy into the public sector, and did so without applying any First Amendment scrutiny, and said, with respect to the public sector, employees could be forced to pay for unions' costs of bargaining with the government, but couldn't be forced to pay for union political expenses. The dissent in that case, however, said that distinction doesn't make any sense. Bargaining with the government is political. That dichotomy doesn't work here. And they also chastised the majority for failing to apply constitutional scrutiny. But that was the law of the land, 1977, and Abood remained the law of the land until it was overruled in Janus about 41 years later. Now, in between that time, there was a great deal of litigation on how to implement Abood, the procedures, what things were charged, what things weren't. But that's somewhat past now, because starting around 2012, the court started to signal that it wanted to overrule Abood. It started first time in 2012, a case called Knox. The court called Abood a First Amendment anomaly, which is very strong words from the high court, and also chipped away at some of its foundations. In 2014, in a case called Harris versus Quinn, which the issue there was whether or not individuals who were not public employees could be forced to pay union dues, the court gave about 6 reasons why Abood was wrongly decided, but then said, well, we don't have to overrule it today because it's good enough to say it doesn't allow Abood to apply the union shop to individuals who are not public employees. In 2016, the court took a case called Friedrichs that challenged Abood head on. However, 1 month after oral argument, Justice Scalia passed and the court deadlocked at 4-4. 2 years later, the court took Janus, and as you all know how the story ends, it overruled Abood. And the court basically did so by saying that the last 40 years have proven the dissenters in Abood to be right, that bargaining with the government is political and can have huge political consequences, that Abood was wrong not to apply First Amendment scrutiny, which made the case even more inconsistent with other First Amendment compelled speech cases that had been heard since then, and that also experience had shown that Abood didn't work. So the Supreme Court overruled Abood and held it unconstitutional, in the public sector at least, to require that an employee pay union dues as a condition of employment. And the court further clarified that a union cannot collect any dues from a public sector employee without first obtaining their affirmative consent. Now, this is a very significant ruling, not just as a matter of First Amendment principle, but as a matter of practical effects. By my calculation, in 2017, over 5 million public employees were required to pay union dues to keep their job. So, for example, here in California, if you wanted to be a public school teacher, the cost of so doing was tithing about $1,000 a year to the California Teacher Association. If you didn't, you couldn't be a teacher. After Janus, all these 5 million public employees, at least in principle, now have the right to choose whether or not they want to support a union. Those who want to do so, of course, are still free to do so. But now that those who don't, who either oppose the union or don't believe it's worth their financial support, no longer have to support its speech in the wake of Janus. However, Janus didn't resolve every issue. If it did, we wouldn't have much to talk about today. The court said at least 4 things that I think informs future legislation and future litigation in this area. The first of which is the court remarked that prior to Janus, unions had enjoyed a considerable windfall from agency fee provisions for the last 40 years, and that unions had been on notice since at least 2012 that maybe their union fee seizures were unconstitutional. So that raises the question, can employees who suffered agency fee seizures recoup money that was taken from them prior to Janus for at least the statute of limitations for 2 or 3 years? And that's an issue being litigated in the courts today. There's at least 48 of what I call clawback suits seeking to recover fees taken in the past. The second thing the court held, as I mentioned, is that a union cannot take an employee's money without their affirmative consent. And the court further clarified that consent has to amount to a First Amendment waiver, a waiver of constitutional rights. Now, the general standard for waiver has been well known for decades. You need clear and compelling evidence that the waiver was voluntary, knowingly, and intelligently made. But what does that mean in this context? What does that mean in the context of a union dues deduction agreement? What does that have to say to meet the requirements of a waiver? And our union dues deduction agreements that were signed prior to Janus, are they still valid? Are restrictions placed on those dues deduction agreements, are they still valid under the First Amendment waiver analysis? That's also a question now pending in litigation. There's about 31 cases by my count that involve these kind of dues deduction agreement cases and what kind of consent is truly necessary. The third thing the court said is that exclusive union representation constitutes, quote, a significant impingement on associational freedoms that would not be tolerated in other contexts. Well, what exactly does that mean? What other contexts is the court referring to? Is the court referring to the context of the idea of unionizing individuals who are public aid recipients but aren't public employees, which is something that's been happening over the last 15, 20 years, where the unions have been extending monopoly representation to individuals who aren't employees, but rather are Medicaid providers or home child care providers? Is that the context which the court was referring? Or was the court potentially suggesting that public sector unionization in and of itself raises constitutional issues? Or maybe is all this just overreading one sentence? We're going to find out. There's a number of cases pending on this, some of which are on a petition for certiorari before the Supreme Court right now. And then finally, with respect to private sector union shop agreements, which of course is where all this started, the court said, we're not deciding that issue today and have no opinion on it. And then dropped 2 footnotes, one of which said, the question on whether or not there's state action under the National Labor Relations Act, which governs most private sector labor relations, there's a circuit split. And then in another footnote, they noted whether there's state action under the other federal statute, which the court held there was back in the 50s, that may be questionable today considering modern state action cases. That's obviously a very strong signal that the court may be looking to decide one of those type of cases sometime in the future. So in short, the future of the union shop arrangement in the private sector under Janus will probably be another issue of future litigation. And so with that, sort of setting the table of what Janus held and some of the issues it left open, I believe turn it over to Stephen to talk about litigation, and then I believe Chuck is going to talk about some of the litigation in more detail of what's out there.
Thanks, Bill. Yeah, I'm going to talk about what I do a lot of, which is how crazy California has reacted in the political world to things. So I remember when I was at the Orange County Register, there was the negotiation between the lead negotiator who represented taxpayers and the union, and they were seen after agreeing to a deal at a downtown restaurant, splitting a bottle of champagne. And that's how the whole system works, right? Or when asked what his ultimate goal was, one union president, I think it was Al Shanker, he said more. That's what they always want. Well, with Janus, it's the first time where public sector unions might have to take less. And it's been interesting watching how they're dealing with it. And I guess the best way to describe it is not well. We've seen it coming for a few years. As Bill mentioned, there was the Friedrichs case, which was based on an Orange County teacher, Rebecca Friedrichs, who just wrote a book about it. And so they knew it was coming, and that was before Scalia's death. And so there's been this kind of yin and yang, and there's been a little bit of a good cop, bad cop among the unions. So in 2014, the California Teachers Association put out a booklet or presentation to their members called Not If, But When. And that's not if, but when mandatory dues are going to end. And what should they do about it? And they focused on increasing the value of the union that the union offers. And actually, get this, listening more to the members. So, I don't have any objection to that. I mean, that's one of the main points of the whole Janus case is, right? You can do it privately. So the CFT president at the time said, I think it's going to hurt, but it need not be the end of the world. Frankly, we're going to have to do the kind of organizing that we should have been doing all these years. Labor got complacent. Yes, force works that way. So you get complacent when you don't have to earn people's business, when you just can take their money. That didn't stop them, however. That kind of positive thing, and it was positive, didn't stop them from trying to preempt Janus with a bunch of rules. I'm focusing mainly on California because, that's what I do, is write about it. It keeps me employed. And they own the legislature. The unions really own the legislature in California. So the first thing they did were they enacted a variety of laws to expand union membership. So if membership might go down, let's make it easier to go up. So AB 83 unionized the Judicial Council, so judicial employees. SB 201 let students who work at universities with university jobs be unionized. I don't know. My daughter, I think my daughter works at a university here, and just the whole idea of it is crazy when you consider they're getting job experience. SB 285, it prohibits public employers from deterring or discouraging union membership. And what's really the killer on this is PERB, the Public Employment Relations Board. That's the same agency that tried to overturn an election in San Diego because the voters didn't have a right to vote. The city needed to meet and confer with the union first on a pension reform issue, and it's a complicated issue, but basically PERB is a very union-friendly agency is my point, and they would be the final arbiter of it. SB 550, the employer must pay the legal fees if union wins a wage dispute. I mean, we see where this is all going. It's all tilting the scales in favor of the unions, and there really isn't anything to push back in California. SB 866 came as a budget trailer bill, so it wasn't even done on the up and up. So employers must allow dues deductions. Cancellation must go through the union. The union decides on the deductions. The union need not provide authorization information to the employer. The union limits mass mailings and gets to approve through meet and confer of any of the information that the employer sends out regarding their Janus rights. And so basically the union's in charge of all aspects of dues deductions. And just the sheer volume, I mean, going through some of this, because just the sheer volume is pretty amazing to me. SB 846, it offers a complete defense to public employers and unions against any legal claims regarding back dues. Delaware and Hawaii, they have done similar things. They created a window to opt out, and it's a short window. New Jersey, Maryland, New York, they followed California's lead and mandated that unions get to have on-the-job orientations with employees so that they could essentially lobby for membership. In Rhode Island, firefighters and police no longer are obligated to represent non-members in grievances. In other words, they're trying to make it more valuable to be a member of the union. I'm not really sure what's left for them to try, but I'm sure they'll come up with something. But we're seeing this whole, what goes on in California, as our legislators always like to talk about, happens other places. So this orientation thing is going to spread, I think. AB 119 requires agencies to negotiate with unions details of the orientations, and it's on and on and on. There are a couple that actually didn't make it, but I'm sure they'll come back. We just had our first unbacked language deadline on Friday, so we still haven't seen, the bulk of what's going to be coming legislatively this session, but I'll be watching it. The second thing they did was something called trap language. Before Janus, the union sent contracts out to employees they knew that Janus was coming down the pike, so they sent renewal contracts and contracts to new employees, where essentially in the fine print, as an employee, you would agree to give up any rights you might gain through Janus. So I'll just read directly from one of the contracts. If I rescind my membership and if existing law changes so that non-members are no longer required by law to contribute, I agree that the contributions authorized above shall continue and this authorization shall automatically renew annually. I mean, think about that. And we have copies of them from all sorts of unions. This wasn't just like one rogue union. I mean, this is kind of what they did. Okay, then the court ruled as expected, and now the funny, haha, was the new line from all the union people I talked to and the newspaper articles is that disastrous attack on working people, it's not a big deal, it's nothing. So before the decision, the American Federations of Teachers president said the billionaire CEOs and corporate interests behind this case have teamed up to deliver yet another attack, blah, 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 you've heard it all. After, Salon had an article, Disaster Averted, and the union president was quoted saying, anyone writing our obituary is going to be sorely disappointed. It won't hurt as badly as thought. Okay, so what is it? And I think the reality of it matters because we're going to be fighting new efforts to deal with Janus, so we ought to know what's really happening. I think it's too early to tell. I mean, all these laws are limiting the ability of people to opt out or delaying it for a year or so, and we have, as Chuck will go over, a whole lot of cases that are going to unwind. So I think it really is legitimately too early to tell. We still don't have reporting deadlines. The Bee just did a story, and the Bee's, pretty friendly to public employee unions, but they just reported, it was a straight news story, that state membership in unions is up by a handful, like 300 people, but even the Bee noted that it's impossible to quit the unions right now, and that a lot of the unions are insisting that people can quit, but you still have to pay a service fee. So I'll go buy a new car, you can pay for it, but you don't get the car. So before Janus, the unions had predicted a 15 to 40% membership declines, depending on which unions. The unions cut their budget before Janus. The NEA cut its budget by $50 million. They should know. So the union message, I think, is right now is similar to the Michigan Education Association's message after the state passed the right to work. ASCME is now down by a third, so I think we need to give it time. And, the NEA reportedly has lost 17,000 members. I haven't checked the numbers out, but I'm seeing various reports. One local Santa Ana union is down 5 to 10%. So I think it's going to start happening. So, okay, so facing the various post-Janus lawsuits, Chuck's going to talk about that, but one of the things we're seeing that is going to be involved with, we're going to have to sue. What we're seeing is just outright resistance. There's one person who filed a suit who the UTLA just isn't giving him his money back until he filed a suit, and they offered to refund him like $433, but they obviously don't want that to be precedential. Since Abood, unions have played games with the political share of the dues, and they've made it very difficult to refund those dues, so we should expect the same thing. Finally, some people say that we're going to see more of these strikes, like the UTLA strike. It's partially an effort to gin up enthusiasm. I saw one commentator declare that it's a way to say that we're still alive as a union. So I think what's kind of interesting is instead of forcing unions to reduce politics, at least in the short term, Janus might be encouraging them to gin up some of the get out on the streets, pushing them to more activism to try to create that tribal mentality that here's the reason you need to be part of our union. And then, that's it. What to expect now? They're going to fight any way they can. Groups that are used to getting more aren't about to take less without a fight, and we need to be able to fight back. So thank you.
Before I get into the substance of my talk, we have a room full of lawyers, judges, solicitor generals, you name it, so I need to do some disclosures just to make sure everything is good. I'm a Democrat. I'm a Kennedy Democrat, and that's John, not Teddy. And some of you in the room are old enough to remember the difference. I liked George H.W. Bush before he died. And I'm a CalPERS pensioner. I get a check every month from my service with the city of San Jose, and I want to get paid every penny that I've earned. I'm a member of the Retirement Security Initiative. I'm chairman of the board. We're a nonpartisan advocacy group advocating to try to save the public pension systems around the country from insolvency. And we work successfully with public employee unions in some states, like Arizona and Michigan, but more often public employee unions are opposed to pension reform. They start with just say no, even where we've had bipartisan support for reforms like Colorado and Pennsylvania. As will be obvious, I'm not a judge, I'm not a solicitor general, I'm not a legal scholar, and I haven't argued cases at the Supreme Court. So you may wonder, why am I here? And looking at the lineup, I asked myself the same question. I think I'm the token politician. But where would you all be without politicians to make all these crazy laws that need to be litigated? You'd all be out of work. So I'm here to talk a little bit about what happens at the intersection of law and politics. In San Jose, we went to the ballot 5 times for tax measures while I was mayor, all with the support of my 11 public employee unions. We went to the ballot 3 times with fiscal reforms and pension reforms, all with the opposition of my 11 public employee unions. We won all the tax cases, and we won all the tax measures, and we won all of the fiscal reform and pension reform measures. Now, as part of my council-approved fiscal reform plan for the city of San Jose, we decided to cut the pay of every employee in the city, including me. Our unions weren't too happy about that, but we got approval from 7 of our unions, including our police officers and our firefighters, for 10% pay cuts. 4 of our unions refused to go along, and so the council imposed 10% pay cuts. In San Jose in 2012, we made national news because we shocked the country when a Democrat mayor and a Democrat city council and a Democrat city and a Democrat county and a Democrat state, the deep blue state of California, took a pension reform ballot measure to the voters and got nearly a 70% yes vote, despite the strenuous opposition of our public employee unions. Now, how were we able to do that? Well, first, San Jose is the capital of Silicon Valley, the 10th largest city in the country. We're usually a winner in the jobs race. Our general obligation bonds are AA+ or AA1. We have 2 independent pension plans that have earned in excess of 7.5% since their inception, but yet we still had billions of dollars of unfunded liability in the form of pension debt and retiree health care obligations, and the cost of paying those on an annual basis was skyrocketing. So what happened in San Jose is that the alternative to doing something compared to doing nothing, there's a lot of pain in doing something. There's a lot of pain in taking on this issue, but there was a lot more pain in doing nothing. And so when the pain of doing nothing was exceeded by the pain, or the pain of doing nothing was worse than the pain of doing something, even my Democrats on the city council were willing to take on the public employee unions to do pension reform and some other things. Now, I did have 100% of my 1 Republican. So it was a bipartisan effort, but we only allowed 1 Republican at a time on the San Jose City Council. I think they're up to 2 now. Well, 3, but you have to take away the ones that are no longer Republicans because of current political environment. But anyway, we don't have very many Republicans in office in the City Council. So I think the Janus decision is going to have an impact on pension reform efforts around the country. It's not just San Jose. In most jurisdictions in the country, the costs of pensions and retiree health care have tripled over the last decade. So that's going to go on. But Janus is going to have an impact on that, both good and bad, and I'll come back to that. But first, the public employee unions and how they operate and how they've reacted. First, my experience with them working at a local level as well as in other states and some nationally is they are smart, they're creative, they're tenacious, and they take the long view. Their job is to get more, and they're very good at it. They look for every opportunity to do so, and you wouldn't believe the opportunities they get when they control both sides of a bargaining table. They are well-funded. They have lots of friends in high places, in red states as well as blue states, just a few more in blue states. Now, Steve gave you a few examples of what their friends in the legislature can do for them when they ask. And, of course, you all know the value of judge shopping. Some of the unions, like police, fire, and teachers in particular, have tremendous peer pressure that keeps people in the unions, even though they may prefer not to be. And there are reasons for that. Many of these factors will lessen the impact of the Janus case as we're beginning to see across the country. Steve mentioned a couple things, but just looking at a brief survey of what's been going on, there are a few organizations that are tracking it. Governing Magazine's one of my favorites. And they recently quoted Lee Saunders, president of the American Federation of State, County, and Municipal Employees, more fondly known as AFSCME. After the Janus case, public service workers are choosing to join AFSCME at a much higher rate than those who drop. The National Education Association, which represents roughly 3 million employees of schools and colleges, says it immediately lost dues from 87,000 people who were non-members who were being charged, but has not seen a significant drop in membership. According to the group's senior press officer quoted by Governing, our affiliates have signed up more new members as of October 1st than they have previously by this point in time. In Pennsylvania, refunding fees to non-members resulted in roughly 15% loss of the $42 million that unions collected from executive branch members and non-members in 2017. But the number of state executive branch employees who were members of unions at the time of the Janus decision has increased from 50,000 to 51,000. In Oregon, the local 503 chapter of SEIU, Service Employee International Union, reported that new union members have outnumbered dropouts by 3 to 2. In California, data from the Comptroller's Office shows an increase in state employee membership, up only slightly, but nevertheless up. In Chicago, the Chicago chapter of SEIU has had about 23,800 members in August of 17, and now has about 26,000. We've seen similar results in Connecticut, Minnesota, and some other states. So the unions have friends in high places. It's always a handy thing to have. And Steve described some of the things that some of the legislatures have done around the country. And where those are successful, you'll see them replicated in other legislatures because there's a very extensive national organization with the unions. They talk. And what works in one state will swiftly be exported to other states. Depending upon how the litigation turns out, some of those will spread and some of them will die, but they will never go away. Now, the litigation may have a big impact on how the Janus decision is ultimately, the impact it ultimately has on the unions, because right now there are people who want to get out of the unions who can't, who want to stop paying dues but can't for some of the reasons outlined. Bill probably should really do this part of the discussion about the litigation because he's involved in it. So I'm not going to talk about the cases in legal detail, but more interestingly in sort of the, what are they trying to do in some states that we're likely to see in others. So Washington, one of the union's friends in high places is the Attorney General. It's always nice to have an AG that's friendly. We learned that in California, but we exported that to Washington. The Janus decision, I'm quoting from the Attorney General, it's posted on the website, you can check it out. The Janus decision does not impact any agreements between a union and its members to pay union dues. And existing membership cards or other agreements by union members to pay dues should continue to be honored. The opinion only impacts the payment of an agency service fee by individuals who decline union membership. That's the Attorney General talking. So, yes, that clear and compelling waiver of the discussed as the Janus requirement, that apparently does not apply to workers who become union members. There is litigation challenging that. Plaintiffs who had signed a membership agreement a while back. It contains an irrevocability clause that limits their ability to resign to a mere 10 days a year around the time that they joined, the one-year anniversary. And if they fail to object during that 10-day period, then it rolls over. And if you don't object the next year, it rolls over and goes on forever. So you have somehow, by joining a union, lost your constitutional rights. But that's just what makes litigation interesting. Oregon, a similar kind of waiver provisions are being litigated. The plaintiffs in an Oregon case all signed agreements to be members of the unions, and the provisions dealt with how they could cancel their membership. And it allows the unions to keep deducting dues from their paychecks even after they've indicated they want to stop their membership. So that's just another tail policy for the unions. California, Steve mentioned a couple of things in California. The service fee was invented by the teachers union in Los Angeles. So yes, you can drop your membership. Yes, you don't have to have dues, but you still have to pay a service fee equivalent to the union membership dues. So as Bill mentioned, dozens of clawback cases, dozens of waiver cases, and there will be others. But I think one thing is clear. If you don't have organizations like Bill's organization, the Federalist Society, and others pressing to enforce the constitutional rights, they don't mean very much. Because an individual worker who's paying $1,000 a year can hardly afford to take on the unions. When the unions have friendly legislatures, friendly members of the judiciary, friendly members of the administrative state, it's all stacked against the workers who want to challenge the union. So are there people who would like to get out and can't? Yes, there are, and it will take litigation to free them up. So about the future, a little bit of guessing. More litigation, yes, that's always good news for lawyers. I think we'll see plenty of challenges, and I think these early cases are going to be the easy wins because they're just so obviously egregious examples of flaunting the intention of the Supreme Court's decision in Janus. But the unions will get creative, and what survives the court challenge in one place will be implemented in other places. And of course, the unions will have allies, especially in those states where they believe the United States Constitution is advisory. And you know where those states are. I think the attempts to frustrate Janus will continue. The early egregious actions will be easy targets, so there's money to be made in attorney's fees in some of these cases. But unions will be creative. They'll be more subtle. They're tenacious. So this fight will go on quite some time. I think there'll be a lot of legislation in blue states as it's successful in one place or another. The unions have lots of friends. They have lots of money. They carry a lot of influence in some legislatures. I think the police unions, the firefighters unions, the teachers unions are going to remain strong. The peer pressure that can be brought against somebody who wants to get out of the union is enormous. In a police union, firefighters, they're living together all the time. Teachers are together in the same school, the same people, all the time. There's plenty of opportunity for that peer pressure to be brought to bear. I think we'll see AFSCME and SEIU be the unions that shrink just because they represent a very diverse workforce. They work in lots of different places. They're not necessarily living with their peers as they work. And so there are many more opportunities for people who want to be independent to be independent. And AFSCME and SEIU have quite a bit less sympathy from the public and in some elected officials, particularly in the red states. But if you look around the country, even in the red states, the public employee unions or groups or organizations, whatever they may be called, bargaining units or not, are strong, they're powerful, they're well influential. And so it's going to be an interesting fight to see how well the constitutional rights that we have get implemented. And finally, back to pension reform, which really is my business when I'm not practicing law. I think the Janus case will have a good and bad impact on pension reform. First, I think there'll be less money for opposing ballot measures. California, we have tried unsuccessfully to get a ballot measure on the state ballot. When we do get one on the state ballot, it'll probably cost us a minimum of $25 million to run statewide. The unions can probably raise $50 million to spend against it. Post-Janus, will it only be $40 million they can raise, $25 million? I don't know, but it'll be more difficult for them. So that will help shift the fundraising battle on some of these measures, I think, for the good. I think it'll be more difficult to negotiate deals. As Steve mentioned, the strike in LA might have just been saying, we're still alive, we're still here, we're still relevant, you have to deal with us. The unions are trying to hang on to their members. They will use pension reform and their opposition to any form of pension reform as a rallying cry. The union is the only people trying to save your pension. We've already seen that in other states. It's a reason for people to stay in the unions and stay connected, and the unions will use it, which means they're less able to negotiate. They will back themselves into a corner, and they won't be able to come to the table, even though many union leaders will admit a pension is a huge problem that needs to be resolved for the benefit of the members, to protect their members, to protect the retirees. When they back themselves into a corner, it's awfully hard to come out and negotiate a solution. So I think pension reform will be harder in some instances. And with that, predicting the future is always an uncertain task, but I will stop with that and come back so we can do some questions.
Well, thank you for the initial rundown. And one of the questions that I had that I wanted to follow up on is the 48 clawback suits that you mentioned, Bill. I don't know if you can speak to that and where that's at as far as litigation goes, and perhaps, you know, how much money is at stake. I mean, normally the presumption is that a Supreme Court decision is automatically retroactive. Along a corollary to this would be, why didn't the Supreme Court do that here? Why didn't they address that question in the case, and where do you see this litigation going?
Okay, so as mentioned, there's about 48 of these clawback suits, so to speak, and most of which are class actions. The amount of money in any given case varies by how many agency fee payers that particular union has. Some of the money could be substantial. We have a case called Hamidi right now, which back of the envelope calculation that if it's successful, looking at about $100 million recovery. But that's sort of on the high end because that case was filed 2 years before Janus, or actually even earlier, so statute of limitations goes back further. Other cases might involve smaller pots of money. But I think all these cases really come down to really one legal issue, and that's what's known as a good faith defense. In most of these cases, one of two union law firms are basically defending. They're basically saying the same thing in almost all of them. And generally speaking, they're not fighting retroactivity. They're not conceding it. They're very careful about that in case something happens that they get lucky on. But they're really not arguing that Janus isn't retroactive because, as you mentioned, Supreme Court decisions are presumptively retroactive under a case called Harper versus Virginia Department of Transportation, unless the court says otherwise. So in Janus, I don't think the court had to say this is retroactive because that's the presumption. Only if they wanted to be only prospective would they have to affirmatively say that. So turning to the future of these cases, the two big issues, one of which is class certification. Without that, obviously, the recovery of any of these cases would be quite negligible, and class certification just rises and falls based on the particulars of a case. But the big thing the unions are arguing on the merits, they assert there's a good faith defense to Section 1983. So almost all of these lawsuits are brought under 42 U.S.C. 1983, which allows an individual to bring a cause of action in federal court for a deprivation of constitutional rights. The unions argue that it is a defense to monetary liability under Section 1983 if they acted with a good faith belief that what they were doing was constitutional at the time. And that's being raised in almost every single one of these cases. Some of the district courts so far, some of which were pre-Janus but after Harris, have accepted that. However, no appellate court has yet accepted that there is a good faith defense to Section 1983 in general or to First Amendment cases in particular. The good faith defense issue gets rather complicated because some courts, actually 5 of them, have held good faith or motive is relevant to some constitutional deprivations brought under 1983, but didn't, in my opinion at least, say that applies across the board. The unions, however, are arguing no. There is a general defense to Section 1983 available to any defendant that if it was constitutional at the time, they're not on the hook for liability. So again, with all that issue being raised in all of these cases, you'll hopefully get probably decisions all over the board. They'll work their way up to the appellate court and then potentially to the Supreme Court. And what's somewhat interesting about that is that assuming one of these cases does make it to the Supreme Court, what the court rules could be or would probably be likely dispositive in all of these cases. You know, if the court held, yes, there is a good faith defense, all of these cases would fail. If the court said, no, there isn't, you know, to First Amendment claims, then virtually all of these cases should be successful. Because under Janus, there's no question what they did was illegal. The only question is, do they have a defense to liability? So over the next few years, we'll see how that plays out in terms of litigation over that.
One other question, and this may be for Bill, although if anybody else wants to, either of the other panelists want to weigh in on it. Justice Alito wrote, designating a union as the employee's exclusive representative substantially restricts the rights of individual employees. And he said that the idea of public sector unionization and agency fees would astound those who framed and ratified the Bill of Rights. That's pretty strong language that garnered 5 votes. So do you think that there's a possibility that in subsequent litigation, the decision might impact exclusive bargaining rights more generally?
My answer is that I hope so, and that we'll soon find out, because there's some cases pending on this, including at the Supreme Court. The one primary place you're seeing this is, starting in about the 2000s, the unions came up with the idea of unionizing individuals who aren't public employees but only receive public aid monies. These include Medicaid providers who provide home-based care and people who provide child care services in their home and get state subsidies for so doing. And so what the unions did in California and Illinois and other states is have them declared to be public employees solely for purposes of unionization and no purposes otherwise, unionize them, and then started to take union dues from their Medicaid or child care payments they received from the state. There was a lot of litigation over that. The first wave was Harris versus Quinn and other cases, which established, no, you can't force those individuals to pay union dues. The second wave of cases says you can't unionize them, that there is no compelling government interest to force these individuals to accept an exclusive representative. And just sort of to back up for those unfamiliar with what exclusive representation means, what it means is the government is designating the union as the individual's sole voice for speaking with the government over certain topics. The union, in fact, basically becomes a mandatory agent, authorized to speak for the individuals and to enter into contracts on their behalf, even if they oppose it. So a union, for example, can waive an individual's rights through collective bargaining. In 14 Penn Plaza versus Payette, a union agreed to basically waive individuals' rights to bring racial discrimination claims in court against their employer by saying they had to go to arbitration. The Supreme Court said that's enforceable. The union did it on your behalf. Exclusive representation also prevents an individual from speaking individually on their behalf because their employer can only listen to the union and to no other voice. And exclusive representation also compels the government or the employer to only deal with the union and to bargain in good faith with the union until impasse. And until that bargaining is done, the employer can't change its policies until bargaining to impasse, which means the government can't change it. So that's sort of the background of why Justice Alito likely said or did say that exclusive representation is a significant restriction on individual rights. So there's a case right now before the Supreme Court called Bierman. It's on a petition for certiorari that says it should be unconstitutional under the First Amendment to extend exclusive representation to these independent Medicaid providers, that irrespective of whether or not it's permissible in an employment relationship, no compelling state interest justifies it outside of that interest. And an issue in Bierman, besides just those Medicaid providers, is the question of, is there any sort of ceiling on exclusive representation? You know, does the government have the authority to basically unionize anyone that it wants to for any reason? Can the government designate a mandatory agent or mandatory representative for anyone? Or is there some sort of constitutional limiting principle? So the line in Janus that exclusive representation is significant impingement on associational freedoms that would not be tolerated in other contexts I believe, and we'll soon find out, if that other context is the unionization of these non-employees. But there's also the question of, is unionization in the public sector permissible whatsoever, even of true government employees? There's also a number of cases, I believe it's 6, that is challenging right now exclusive representation of public sector employees, that even employees cannot be forced to accept an agent for dealing with the government. And one of those cases is also pending on a petition for cert right now before the court. It's called Uradnik. Both those petitions were filed in December, so my guess is after the way briefing falls, we'll have a decision from the court in April or May. And even if those are denied, there's more cases like them in the pipeline.
Steve, one question that maybe you can field. You mentioned that the unions had been projecting a much greater fall off, 15 to 40%, I think was the figure you gave in union membership. That hasn't materialized. You gave some of the reasons for that. Are there outreaches that are being done to explain to workers what their rights are in this regard? And if so, could those have potential impacts in the future?
Yeah, and it seemed like there, and Chuck detailed some of that too. It looks like in some cases the union membership is up, in other cases it's down a little bit. And police and fire is always obviously going to be the toughest. But I've seen it, like the California Policy Center has, they've been running billboards encouraging people to opt out of the union, and there have been some, I think, organized efforts that I'm seeing around the state. I don't know. I don't know how much fruit it's bearing, and the big problem is deadlines. I mean, if the unions aren't allowing people to opt out, and they're claiming that you still have to pay a service fee, or they're waiting for the trap language contracts to expire, which, yes, you get a year, and then you have like 30 seconds to exactly, get it right. And we saw that with Abood, with the political contribution since what was that 78, when you're allowed to withhold your anything tangentially related to politics, but the unions get to decide how much that is. They get to decide how much is politics, and then you have to fill the right form. And I've talked to people who have said their form has been ignored. And there was that one case with Thomas Few, UTLA teacher, who they just ignored. He tried to quit, and then, hey, I want to break up with you, and just ghost you, I guess, if you're trying to, and then they don't do anything, and they still take the money, and then anyway, that's where I think these cases are going to be really important. It's kind of, yeah. So I don't have numbers though, but they did. I know the Policy Center looked at Santa Ana specifically and saw some decline in membership.
Chuck, you mentioned that in some ways this is actually strengthening, or at least the unions are trying to portray the view that this is strengthening their hand. What advice do you have for those public servants who are in your position, or in the current position that you used to have, on how to negotiate with the unions and how to work through this? There's obviously a huge budget problem, and what can they do to help rein this in?
Well, the first rule would be to try to follow the United States Constitution, which might be a novel idea at the bargaining table, but that would be where I would start. But the cities and counties facilitate this by collecting the dues. There's no reason why they have to do that other than unions have cut a deal so that we collect the money for them. So if the cities and the counties decide that they want to follow the United States Constitution and they want to help people protect their rights, so they could insist on certain behaviors by the unions that would comply with the Janus ruling. And so that would be something that maybe you can get a majority on a legislative body to agree that we should follow the Constitution and we should apply this process in a way that follows the Constitution. Who can argue with that? Well, there are people who could.
Yeah, I think that, that SB 866, I think the reason the unions were so intent on getting that is it allows them to control the whole process and making sure that the deal isn't between the union members and the union. It has to go, the union controls everything, and that the public employer can't do anything that the union doesn't dictate. So.
And we have some time here, so I don't want to ask all the questions. If there are any questions that anyone has in the audience. Do we?
Yeah, hi, Steve. You mentioned the LAUSD strike may have been precipitated by the union's desire just to justify its existence. But the deal that was struck, I understand that a lot of the LSU, the union members, were very upset insofar as they didn't really get anything more than the district was offered before. Could this backfire on the union by taking by forcing their members to strike for 7 days for no reason? Apparently, the Twitter feeds were pretty nasty by union members against the union. So might this actually backfire on them by having some of the members say, why am I even in the union?
I mean, one can only hope, but John, I mean, it was interesting that I was talking to some people on a piece I was going to write, and they said, yeah, what the final deal, and I didn't look at it, the language, but they said it really was nothing different than what the district offered early. So, and I did see some reporting suggesting that indeed it was meant to just excite people. So yeah, if they find out, if the teachers figure out they've been played, I mean, that could actually help the hand. And I did see some billboards in Los Angeles encouraging people to back out of Janus. So it's a good story idea. I'll take a look and see, but I don't know yet.
I have two inconsistent questions. First, with respect to the potential of having to pay back for several years on the retroactive question, like to Friedrichs or whatever. Did the unions insure against that risk of loss? Or are they self-insured? That's number one. And second, with what you had said, Chuck, about, or maybe it was Steve who talked about the counties, cities, whatnot, collecting the dues. Bill, are you guys suing the counties and cities for participating in an illegal action?
Well, on the first question, I would assume that most of the major unions are insured, but I think what's somewhat interesting is that in almost all dues deduction agreements you'll find, there's also an indemnity clause in which the union agrees to indemnify the public employer for its legal expenses if it gets caught doing something illegal at the behest of the union. And I actually think that's a bit of a tell that the unions knew what they were doing was legally risky prior to Janus, and even now after Janus with the revocations, that they actually had to agree to indemnify the employer in order to convince the public employer to agree to those dues deductions. And then with respect to the counties, the answer is generally yes. Every case is somewhat different, but usually both the union and the public employer is sued, because ultimately it's the public employer, or sometimes a state controller, that's taking the money. It's the executioner of the unconstitutional act, which sort of brings me to SB 866, which we've mentioned twice. To reiterate, that's the law that says a California public employer, when it comes to dues deduction, has to just do whatever the union says and close its eyes. It can't be involved. So if an employee sends a letter to the public employer, let's say the school district, saying, I do not consent to paying dues, stop now, the school district has to ignore it. It can only listen to the union. I think that's unconstitutional, or at least unconstitutional in the sense that it doesn't absolve the government from the unconstitutional act of taking that individual's money. Ultimately, it's the government that's violating Janus. Janus says the government cannot take an individual's money for union dues without their consent. If an individual informs the government, I do not consent, it's not a defense to say, well, the union told us that it was okay. We're just following union orders. I mean, just following union orders isn't a legal defense.
Not yet.
Not yet. So this will be litigated, the propriety of SB 866, and we'll see ultimately what the courts hold. But personally, I don't know if it's facially unconstitutional, but in terms of the idea that absolves the public employer from listening to an employee's revocation request, I don't see how it could.
Yeah, there were two bills that AB 1937 and AB 2049 that actually didn't pass, but will probably be back, that they would specifically preclude governments from unilaterally honoring employee requests to stop dues. So it just shows what they're really focused on that kind of issue. Yeah.
I think we had another question, right? A couple of questions over here.
Thank you. I happened coincidentally to have been at a talk given by Rebecca Friedrichs a few days ago, and she mentioned that there's actually some legislation being proposed that would require the state to compensate the public employees unions for the loss of dues due to the Janus decision. Does anybody know anything about that?
No, but wow.
Sounds creative.
I know a bill was recently introduced in Oregon to that effect, which would basically require that every public employer pay an assessment, which would then be given to the union. So basically, the employer the union is bargaining against has to fund the union. Now, I know there's some debate, even among the left, of whether or not that's a good idea. So all labor law has been structured since the New Deal to have a division between the union and the employer, public or private, the idea being that otherwise it's exclusive. So under federal law, an employer cannot give any money or thing of value to a union. And there's generally similar provisions in public sector laws, because otherwise it looks like the government's controlling the union. The union looks like a puppet. But in the wake of Janus, some people are saying we have to, some union advocates are saying we have to turn to that. Other union advocates and thought leaders are saying no, we're basically giving up our soul. And if we agree to be funded by the very entity we're bargaining against. So the idea of government funding of unions is something that's sort of out there and being debated, even on the left. Now, from a constitutional point of view, it does get around some issues of forced speech, depending on how it's done. Because if the government just directly funds, just say gives $1 million check to AFSCME or any public sector union, you can't argue that's compelled speech. That's government speech. So it is a workaround around Janus. You may have a discrimination claim as to who's entitled to such money, but it is a workaround depending on exactly how they do it. The question is, are unions so desperate that they're actually willing to literally be, government-funded interest groups?
Well,
And,
if they
we'll
can
have to
control
see.
the government, what's wrong with that?
Yeah, usually it's the government's the union interest group in California.
So the government, in many instances, certainly in California, is already paying for the union operations with release time. And so in San Jose, we paid for release time for all of the union reps, theoretically to, engage and help the workplace and deal with issues. But we ended up paying for the firefighters to go to the golf tournament that was raising money for the union because that was union-related business, release time. So release time is very broad. And my guess is that in many jurisdictions, the government is already paying for more than what it actually takes to negotiate with the government. So I don't see, since we're already a little bit pregnant, why the government shouldn't just pay for the whole operation.
And an example, that's actually the federal government. So the federal government's always been right to work. There's never been compulsory unionism of compulsory fees in the federal government, but there's very robust release time or official time provisions in federal law that result in the federal government paying, I believe the number was $184 million in terms of amount of time during 1 year of basically giving government officials time off to be union officials, paying them to do it. So that was the federal government's reaction, or the federal government union's reaction to not having compulsory fees. It's very possible we'll see that increase more on the state level now that they can't rely on compulsory union fees.
We had a question here, a couple questions, and we had someone in the back here as well.
Do you have any comments on the trap provisions that were signed right before Janus? It seems like there's some basic issues that there's no consideration with people signing, like some basic 1L contract thing, that there's no consideration on these agreements if all they're doing is signing something saying, yeah, I'll agree to continue paying money to you. Has this issue been litigated? And on a little bit of follow-up too on the good faith defense, it seems like this is also like a absolute immunity on steroids, where I'm not aware of any case in which a good faith defense has ever been used for 1983. Plus, even with something like qualified immunity, that only applies to the actual official. It doesn't apply to the entire entity. Do you have any thoughts on that?
Absolutely. I mean, those are two very good points. With respect to the first, the argument is being made in some cases that a dues deduction authorization is not a contract within the meaning of that word because there's no consideration. It's merely an authorization to have, it's a wage assignment, but it's not consideration because there's nothing in return. And part of which reason is almost every dues deduction authorization says this dues deduction authorization is not conditioned on me remaining a union member. And that's why they think they can continue to take money from individuals even after they resign. So if it's not contingent on being a union member, what is the consideration supporting that contract? But I think ultimately the revocation windows or trap windows really come down to a question of constitutional waiver. Even if they meet the standard of a contract, do they meet the much higher standard of a waiver of First Amendment rights? And an argument is being made that especially all those signed prior to Janus could not have been entered into voluntarily, because at the time they were entered into, they didn't have a choice. Their choice was to sign this and pay union dues or to not sign it and pay union dues. So pre-Janus authorizations weren't voluntary. And also they didn't have language informing them of their rights under Janus, which of course didn't yet exist. So the idea of whether or not pre-Janus authorizations are valid is being litigated on those revocation or trap windows. Turning to the good faith defense, it's interesting, you mentioned qualified immunity. The unions are saying this isn't an immunity, but any party that doesn't have an immunity is entitled to a good faith defense because it'd be unfair for them to be held liable for things that people who have immunity wouldn't be. So, exactly, it's sort of, I have trouble wrapping my mind around it, but they're essentially claiming if we don't have immunity, we have an offense that's basically the exact same thing as an immunity. I submit it doesn't exist. The unions are arguing that it does. Many of this is being litigated all over the country, and we'll see ultimately how it turns out.
I think we got one question here, and then we have a guy in the back, so we may not have enough time for all of them. But
So what happens if Uradnik wins her case? In regards to exclusive representation going forward, what's the implication of that for the unions in going forward?
With respect to the Bierman case, is that okay?
I'm talking about the exclusive representation clauses that I think Professor Uradnik is challenging.
Oh, Uradnik, sorry, I didn't hear the first word. If that were true, if Uradnik was successful and the court held as unconstitutional under the First Amendment to designate an exclusive representative, that would basically invalidate most public sector labor laws. Almost all of them are predicated on the idea that there is an exclusive representative and has certain authorities and it goes from there. Now, could you structure a different labor law without exclusive representation? Sure. It exists in Europe, it exists in other places. So exactly how it would change is a good question. But in terms of what exists now, which is basically an exclusive representation model all across the board, it would invalidate the heart of those statutes, and you'd have very strong questions concerning severability of whether all the other parts of those labor laws could survive without that core exclusive representation being there.
okay, I think we got a final question back here.
Actually, Mr. Reed kind of beat me to it. I was going to bring up release time, but I've had enough time to think of another question, so lucky you. I'm Tim Sandifer from the Goldwater Institute. We're litigating a case called Fleck right now, which tries to take the Janus principles and move on to the next step, which is to say that just as you shouldn't be forced into representation by a union, so lawyers should not be forced to join bar associations for precisely the same reason. I wanted to ask what you think are other possible expansions of the Janus principle. One that comes to mind is, do you think it's possible that the principle could be used against compulsory student fees? I know that's been attempted probably a decade or so ago now, to prohibit colleges from forcing students to subsidize speech that they disagree with and so forth. It seems pretty distinguishable to me. Do you think that it's possible that Janus could put some more strength back into that kind of an argument?
I think so, potentially. So in Southworth, the court upheld compulsory student fees, but it did so under a very different paradigm than the compulsory bar fees or compulsory union fees. Basically, the court said you're funding a public forum. So it's not as if you're being forced to support one particular organization. The court applied, I guess you can call it like a forum type analysis to justify those kind of fees. Whether or not the court would want to walk back from that and put it more under the Janus paradigm is a very good question. However, speaking with the bar fees, that very much is under the Janus paradigm. So parallel with Abood, which again allowed compulsory union fees in the past, the court issued a very similar line of authority for compulsory bar fees, a case called Keller being the main one. It was basically Abood for lawyers. And so now with Janus out there, the question of whether Abood for lawyers is still valid is a very good question. Of course, as was mentioned, is litigated in Fleck. Fleck was pending actually before the Supreme Court, and the court recently GVR'd it for further consideration in light of Janus. So at least the Supreme Court believes that Janus does have an effect on bar association fees to some degree.
All right. Well, I want to thank the panelists for enlightening discussion.